Good morning and welcome to the Senate Committee on Commerce and Labor. Madam Secretary, please call the roll.
Senator Daley. Here. Senator Ellison. Senator Flores. Senator Lang. Senator Rogish. Here. Senator Scheibel. Here. Senator Steinbeck. Here. Senator Pizzina.
Present. Thank you so much. We have all members present and accounted for this morning, and we'd like to welcome our audience in Carson City, Las Vegas, as well as any that are following online. Before we begin with the marathon work session, I'd like to make several housekeeping announcements. I'd like to remind everyone to please silence all of your electronic devices while in the committee room. Members of the public may provide testimony in various ways, all of which are listed on the agenda. You may also submit public comment in writing, either in addition to testifying or in the place of testifying. And if you wish to testify in person, please sign in by the door and leave your business card with our committee secretary. When testifying in person, please turn on the microphone to speak and off to listen, as we have others that are listening in Las Vegas, as well as those following online. Please also remember to state and spell your name for the record. Anyone who'd like to receive electronic notifications of scheduled bills and access to the committee's meeting materials may do so by signing up on Nellis on the legislative website. Committee members will be using their laptops to view handouts and exhibits, and many a work session this morning as well, potentially. So please do not view this as a sign of disrespect or inattention. I'd also remind everyone that during a work session, there is no testimony. All of the testimony in support and opposition and neutral has already happened. So when we do a work session, we may call someone up if we have a question, but there will be no testimony. And with that, I am going to open up our marathon work session today and hand it over to Mr. Ashton.
Thank you, Chair Pizzina. For the record, Patrick Ashton, Research Division, Legislative Council Bureau. As a nonpartisan member of the legislature, I can neither support nor advocate for any measures before you today. Members, before I will walk you through the first item on the work session today, Senate Bill 9, I would like to mention that you received by email the combined work session document. You also have binders with all the work session documents on your desks. And also all the work session documents are available on Nellis for the public to view. And there's also a limited number of hard copies on the desk here in the corner. For the sake of time, I will concisely summarize the 28 bills and amendments before you today. That means I may only state on the record parts of the bill summaries and pick certain highlights of the attached amendments as applicable. If you have any questions or concerns regarding a bill or amendment, please feel free to ask, and at the discretion of Chair Pizzina, I would be happy to provide additional context or details. Bill stakeholders in the audience may be able to respond, or Mr. Coolmay could lend his legal expertise. With that, Chair Pizzina, I will start with Senate Bill 9. Senate Bill 9 was heard on February 12th. It brings state law into compliance with federal law by requiring certain health insurers and other providers of health coverage to respond within 60 days to a state agency's inquiry regarding a payment claim for a medical item or service. There were no amendments. Thank you, Chair.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 9? Okay. Seeing no questions, I will entertain a motion to do pass Senate Bill 9.
So moved.
Second.
Thank you so much. We have a motion to do pass from Senator Scheibel. We have a second from Senator Daley. Do we have any discussion? Okay. Not seeing any. All in favor, please say aye. Aye. Any opposed, say nay. Okay, thank you so much. Please note that Senate Bill 9, the motion carries unanimously, and I will assign that floor statement to Senator Rogish. Mr. Ashton, please proceed with Senate Bill 11, and thank you.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 11 was heard on February 19th. It requires the reduction of the weekly extended benefit amount payable to a person for any week during a period in which federal payments to the state are reduced as a result of sequestration by a percentage equal to the percentage of the reduction in the federal payment. There were no amendments. Thank you, Chair.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 11? Okay, wonderful. Not seeing any, I will entertain a motion to do pass Senate Bill 11.
Motion to do pass Senate Bill 11. Thank you.
Thank you so much,
Second.
Vice Chair. We have a motion from our Vice Chair. We have a second from Senator Flores. Do we have any discussion? Okay, great. Not seeing any discussion. All in favor, please say aye. Aye. Any opposed, say nay. All right. The motion carries unanimously to do pass Senate Bill 11, and I will assign that floor statement to Senator Ellison. All right. And that will move us to Senate Bill 16, Mr. Ashton.
For the record, Patrick Ashton, Research Division LCB. Senate Bill 16 was heard on February 10th. It revises the kinds of disciplinary actions the State Contractors Board may take or impose on contractors. Amendments. The State Contractors Board proposes the attached conceptual amendment to the work session document. In summary, the amendment revises in Section 1 the term person with unlicensed contractor to clarify that the board may refuse for up to a year to issue a license to the unlicensed contractor and makes certain exclusions from Section 2, subsection 14. Thank you, Chair.
Thank you so much, Mr. Ashton. All right. Do we have any discussion on Senate Bill 16? Okay. Not seeing any discussion, I will take a motion to amend, do pass Senate Bill 16.
So moved.
Thank you so much. We have a motion from Senator Scheibel. We have a second from Vice Chair Daley. Do we have any discussion on Senate Bill 16? Okay. Not seeing any discussion, all in favor, please say aye. Aye. Any opposed, say nay. All right. Wonderful. Senate Bill 16 passes unanimously. The motion carries, I should say. And we will assign that floor statement to Senator Daley. And with that, we will move to Senate Bill 44, Mr. Ashton.
For the record, Patrick Ashton, Research Division LCB. Senate Bill 44 was heard on February 7th. It establishes federal standards for the safeguarding of customer information in state law and enhances regulatory oversight of providers for certain financial services. Amendments. The Commissioner of the Division of Mortgage Lending is proposing to amend subsection 2 of Section 25 by clarifying that an agency is only exempted when not acting as a mortgage servicer. Thank you, Chair.
Thank you so much, Mr. Ashton. All right. Do we have any discussion on Senate Bill 44? Okay. Not seeing any discussion, I will take a motion. I will accept a motion to amend, do pass Senate Bill 44.
Motion to amend and do pass Senate Bill 44.
Thank you so much. We have a motion from Senator Daley. Do we have a second?
Second.
We have a second from Senator Scheibel. Is there any discussion? Okay. Not seeing any. All in favor, please say aye. Aye. Any opposed, say nay.
And I want to reserve my rights if I could.
Okay. Please note that Senator Ellison has voted no on Senate Bill 44, and the rest of the committee has voted to move it forward, and he has reserved his right to change that on the floor. And we will assign that floor statement to Senator Lang. All right, and that will move us to Senate Bill 124. Mr. Ashton.
For the record, Patrick Ashton, Research Division LCB. SB 124 was heard on February 21st and authorizes the Board of Medical Examiners to issue a limited license to practice medicine to a graduate of a qualified foreign medical school who meets certain criteria and possesses certain qualifications. Amendments. Senator Doniate proposes the conceptual amendment which is attached to this work session document. In summary, it changes in Section 1, subsection 1, to allow the board to issue a limited license to an applicant who holds or has held a valid and unrestricted license to practice medicine issued by a foreign country other than Canada, completed a residency program or performed the duties of a physician in that foreign country within the last 5 years immediately preceding the date on which the application is submitted, or upon a date greater than 5 years that has been deemed as permissible by the board. Moving on to item 5 and 6 of the work session document, it adds in subsection 2F that an applicant must also pass step 3 of the United States medical licensing examination. That's a requirement for a licensee to be supervised by a fully licensed physician who meets certain qualifications and set forth a supervision agreement between the licensee and physician that must be approved by the board. And in item 9, it revises subsection 4 to authorize instead of require the board to issue an unrestricted license to practice medicine to a licensee under certain conditions. Thank you, Chairperson.
Thank you so much, Mr. Ashton. That was a mouthful. So any discussion on Senate Bill 124? Yep, Senator Steinbeck.
Just a quick statement. I just want to congratulate everybody involved. A lot of work went into this to get this to where it is now, and I think it got to be an excellent bill. So thank you.
Thank you so much. All right, seeing no further discussion, I will accept a motion on Senate Bill 124 to amend do pass.
So moved.
Okay, thank you so much. I'll take excuse me. Who was it? Okay, thank you so much. Senator Steinbeck, we have the motion. Do we have a second?
Second.
Thank you so much. We have a second from Senator Flores. And do we have any further discussion on this one? Okay, thank you so much. All in favor, please say aye. Aye. Any opposed, say nay. All right, thank you so much. The motion carries on Senate Bill 124, and Senator Doñate will be assigned the floor statement. And that will move us to Senate Bill 128.
For the record, Patrick Ashton Research Division, LCB. Senate Bill 128 was heard on April 4th. It prohibits certain public health insurers from using an artificial intelligence system or an automated decision tool to be used for certain actions related to prior authorization for healthcare services and coverage. Senate Bill 128 requires certain healthcare providers to discuss with and inform a patient who has been diagnosed with a medical condition that is regularly treated using stem cell therapy about the potential use of stem cell therapy to treat the condition, and inform the patient of options that may be available to the patient for donating, banking, or storing stem cells. Amendments. Members, there are 3 amendments attached to the work session document, and I will briefly summarize the third one, which was submitted after the bill hearing. This amendment revises certain sections that a health insurer shall not utilize, employ, or rely upon on an AI system or automated decision tool. It adds to various sections that health insurers requiring prior authorization for medical or dental care shall authorize coverage for a healthcare service or dental service that is a covered service and that has been recommended for the insured by a provider of healthcare acting within the scope of his or her practice, with certain exceptions applicable to these sections. Thank you, Chair.
Thank you so much, Mr. Ashton. All right. Do we have any questions on Senate Bill 128? Okay. With that, seeing no questions, I will entertain a motion to amend do pass Senate Bill 128.
So moved.
Okay, wonderful. We have a motion from Senator Flores, a second from Senator Lang, who helped present that bill. And with that, do we have any questions, any further discussion on Senate Bill 128? Okay, seeing no further discussion, all in favor, please say aye. Aye. Any opposed, say nay. Okay, wonderful. The motion carries unanimously, and the floor statement will be assigned to Senator Neal. And that will move us to Senate Bill 170. Mr. Ashton.
For the record, Patrick Ashton Research Division, LCB. SB 170 was heard on March 10th. It requires a firefighter or volunteer firefighter to submit to a cancer screening upon employment, commencement of coverage, and annually while employed. This bill revises and expands the requirements for administering such physical examination and provides the screening test for various cancer types. Amendments. Senator Steinbeck proposes the conceptual amendment which is attached to the work session document. In summary, the amendment removes in Section 1, subsection 11, the requirement that a firefighter or volunteer firefighter shall submit to a cancer screening upon employment. Instead, it authorizes an employer to provide such firefighters with a cancer screening upon employment under certain circumstances. In Section 2, it makes also various changes to the requirements of a physical examination and cancer screening. Thank you, Chair.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 170? All right, not seeing any questions, I will entertain a motion to amend do pass Senate Bill 170.
So moved.
Thank you so much, Senator Scheibel. And we have a motion from Senator Scheibel, a second from Senator Daly. Do we have any further discussion on Senate Bill 170? Okay, not seeing any. All in favor, please say aye. Aye. Any opposed, say nay. All right, wonderful. Senate Bill 170 passes, the motion passes unanimously through committee, and we will assign that floor statement, of course, to Senator Steinbeck. And with that, Mr. Ashton, Senate Bill 171.
For the record, Patrick Ashton Research Division, LCB. SB 171 was heard on March 21st. It prohibits a healthcare licensing board from taking any disciplinary action or adverse action against a healthcare provider or disqualifying persons from licensure solely for providing or aiding in the treatment of medically necessary gender-affirming healthcare services that are lawful and consistent with professional standards in the state. Further, the bill prohibits the governor of the state of Nevada from surrendering or issuing a warrant for the arrest of a person charged in another state for a crime involving the provision, aid, or receipt of medically necessary gender-affirming healthcare services, unless, among other exclusions, the acts also constitute a criminal offense in the state. Finally, the bill prohibits state agencies from using government resources or providing information to support investigations or proceedings from other states in such circumstances. There were no amendments. Thank you.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 171? Okay. With that, I will accept a motion to do pass Senate Bill 171.
I move to pass Senate Bill 171.
Thank you so much. We have a motion from Senator Scheibel. Do we have a second? A second from Vice Chair Daley. Is there any further discussion? Okay. With that, all in favor, please say aye. Aye. Any opposed, say nay. Okay. And Senator Rogich, I'm so sorry I missed it. Okay, thank you. Okay, so please note that the motion does carry on Senate Bill 171, and we had Senators Ellison, Steinbeck, and Rogich voting do not pass, and that one will be assigned to, the floor statement will be assigned to Senator Orenshaw. All right, and with that, Mr. Ashton, let's move to Senate Bill 172.
For the record, Patrick Ashton Research Division, LCB. Senate Bill 172 was heard on March 3rd. It establishes the Agricultural Workers' Bill of Rights by prescribing certain rights of a worker engaged in various agriculture or farming services or activities. Amendments. Make the Road Nevada proposes the following amendments: to retain in Section 1 the deleted provisions regarding the exemption for agricultural employees relating to overtime, and remove Section 18, which requires the Labor Commissioner to adopt regulations extending certain provisions related to the payment of wages and certain other employee benefits to such workers. Thank you, Chairperson.
Thank you so much, Mr. Ashton. With that, do we have any questions on Senate Bill 172? Okay, Senator Steinbeck?
Yes, I'm going to vote no on this bill, but I just want to reserve my right to change it on the floor. I'm certainly for the collective bargaining portion of this bill. Thank you.
Okay, thank you so much, Senator Steinbeck. Seeing no further questions, I am going to accept a motion to amend do pass Senate Bill 172.
Motion to amend and do pass.
Second.
Thank you so much. We have a motion to amend do pass from Vice Chair Daley, a second from Senator Scheibel. Do we have any further discussion on 172? Seeing none, all in favor, please say aye. Aye. Any opposed, say nay. Okay. Please note that Senators Steinbeck, Ellison, and Rogich did vote nay. However, this motion does carry, and I will assign the floor statement to Senator Flores. And with that, Mr. Ashton will move to Senate Bill 173.
For the record, Patrick Ashton Research Division, LCB. SB 173 was heard on April 4th. It establishes environmental provisions relating to disposable foodware and standard condiments, various consumer products containing certain chemical substances, and mitigation efforts of certain severe heat conditions. Amendments. Senator Neal proposes the attached conceptual amendment to the work session document. In summary, the amendment removes from Section 2 bowls, trays, plates, cartons, cups, and lids, and explicitly excludes these items from the definition of disposable foodware. It deletes Sections 3 and 4 concerning recycled black plastics and plastic bottles. It replaces in Section 26 the penalty of a misdemeanor with a $1,000 fine, revises the definition of blighted area, that the existence of urban heat islands may be considered blight, and prohibits restaurants from using plastic cutting boards effective on July 1st, 2027. Thank you, Chairperson.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 173? Okay, Senator Steinbeck?
Sorry to take all the time today, but I'm going to vote yes on this and again reserve my right to change. Thank you.
Thank you so much, Senator Steinbeck. All right, seeing no further questions, I will accept a motion to amend, do pass Senate Bill 173.
So moved, Madam Chair.
Thank you so much. We have a motion from Senator Flores and a second from Senator Daly. Do we have any further discussion on 173? Seeing none, all in favor, please say aye. Aye. All opposed, say nay. Okay. Thank you so much. Please let it be noted that the motion does carry. The floor statement will be assigned to Senator Neal and that Senators Ellison and Rogich voted nay. And with that, we are going to move Mr. Ashton to Senate Bill 191.
For the record, Patrick Ashton Research Division LCB. SB 191 was heard on March 14th. It requires, with certain exceptions, an individual who records with an audio and video recording system certain court-related proceedings to be certified as a legal video recorder from the Certified Court Reporters Board of Nevada. Amendments. Senator Daly proposes the attached conceptual amendment to the work session document, which in summary authorizes the board to adopt regulations concerning digital reporters, clarifies in Section 4 that each party to a proceeding is entitled to a copy of the record of the proceeding, revises Sections 3, 5 through 15 and 17 to create a two-tiered certification system for legal video recorders through regulations prescribed by the board, and adds in Section 16 certain increases to the fees. And see also the attached document that outlines these fees in Section 16. Thank you, Chairperson.
Thank you so much, Mr. Ashton. We're giving you a workout today and more to come. All right, any discussion, or I should say any questions on 191? Okay, Senator Rogich?
Thank you, Chair. I'm going to vote yes out of this committee, but reserve my right to change on the floor.
Thank you very much. And Senator Ellison? Ditto. Got it. All right, thank you so much. And Senator Steinbeck?
Ditto, Chair.
Thank you, all three of you, very much. And with that, I'll accept a motion to amend, do pass Senate Bill 191.
Hold on. I had a comment.
Oh, you have a comment. I'm sorry.
Yes. Thank you, Madam Chair. And just for the committee and various things. So we did a lot of work. We're mostly there. We have a conceptual amendment. Everyone wants to see the language, as do I. There might be a little more work on the other side, but for the purposes of drafting, I wanted to make clear that digital recorders and video recorders for drafting purposes are going to be captured in the same thing. So if you're recording by audio, video, or both, you're going to come under the legal video recorder portion of this. For drafting, wanted to make that clear for them and the committee as well. So that was it.
Thank you so much. Do we have any further questions on 191? Okay. I will accept a motion to amend, do pass Senate Bill 191.
So moved.
Thank you so much. We have a motion to amend, do pass from Senator Flores. Do we have a second? A second from Senator Lang. Do we have any further discussion on 191? All right. I'm not seeing any further discussion. So with that, I will say all in favor, please say aye. Aye. Any opposed, say nay. Okay. Thank you so much. This motion carries unanimously out of committee, and the floor statement with noted comments from the committee. And with that, we will assign the floor statement to Senator Daly, and we will move to Senate Bill 198. Mr. Ashton.
For the record, Patrick Ashton, Research Division LCB. SB 198 was heard on March 14th, and for the sake of time, I will go straight to the amendments. Senator Daly proposes the conceptual amendment attached to the work session document, which in summary deletes all provisions of this bill relating to the revocation of the license of a cannabis establishment, removes the term compensation from the provisions of this bill, and instead provides a new definition of other compensation, and provides in Section 3, subsection 1, that an employer faces certain penalties if he or she fails to pay the wages earned and unpaid, and they are outlined on the work session document. Thank you, Chairperson.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 198? Okay. With that, I will accept a motion to amend, do pass Senate Bill 198.
So moved, Madam Chair.
Thank you so much, Senator Flores. Do we have a second?
Second.
A second from Senator Scheibel. Do we have any further discussion on Senate Bill 198? Okay. With that, all in favor, please vote. Please say aye. Aye. Any opposed, say nay. Okay, thank you so much. Please note that Senators Ellison, Rogich, and Steinbeck voted nay, and the motion did carry, and we will assign the floor statement to Senator Daly. And with that, we will move to Senate Bill 199. Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 199 was heard on April 2nd. It establishes a framework for the regulation of artificial intelligence systems in Nevada. Amendments. Senator Neal proposes the amendment attached to the work session document, which, in summary, makes the provisions of Section 6 applicable only to certain entities as set forth in items 2A through D on the bill page. Removes in Section 7 that a person registering must include the Social Security number of the applicant in the application. Removes Sections 9 and 10, which requires artificial intelligence companies to have certain policies. Deletes Section 19, which prohibits a K-12 public school teacher from using an AI system to generate any class lesson plan, and instead requires the working group to develop a policy concerning the use of artificial intelligence for lesson planning, and revises Section 26, subsection 2G, that the working group must include 5 pupils. Thank you, Chairperson.
Thank you so much, and hopefully everyone's had a chance to look at all of the amendments in the working document on Senate Bill 199. Do we have any questions on 199? Senator Rogich?
Actually, with the amendment here, I'm going to vote this out of committee with reserving the right to change on the floor so that I have a chance to look at the amendment and then also encourage the parties to continue discussions.
Thank you so much. Yes, a lot of amendments came in very late, and I appreciate all of the hard work of the committee. Okay, with that, on Senate Bill 199, not seeing any further questions, I'm going to accept a motion to amend, do pass Senate Bill 199.
So moved.
Thank you so much. We have a motion from Senator Daly. Do we have a second? A second from Senator Flores. Do we have any further discussion? Okay. With that, all in favor, please say aye. Aye. Any opposed, say nay. Okay. So please note that we did receive nays from Senators Ellison and Steinbeck, but the motion did carry, and we will assign the floor statement to Senator Neal. And with that, we will have you move to Senate Bill 231, Mr. Ashton, and thank you.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 231 was heard on March 19th. It sets forth the requirements for the installation and maintenance of secure truck take-back bins by collectors that are authorized under federal law to engage in truck take-back collection and the destruction of home-generated pharmaceutical waste. There were no amendments. Thank you, Chairperson.
Thank you so much. Do we have any questions on Senate Bill 231? Okay, not seeing any questions, I will accept a motion to do pass Senate Bill 231. Thank you so much. We have a motion to do pass from Senator Lang. Do we have a second? We have a tie. I will give it to Senator Scheibel. And with that, do we have any further discussion on 231? Okay, not seeing any. All in favor, please say aye. Aye. Any opposed, say nay. Okay, Senate Bill 231's motion carries unanimously, and we will assign the floor statement to Senator Stone. And with that, Mr. Ashton will move to Senate Bill 260.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 260 was heard on March 26. It requires certain employers to protect their employees from poor air quality. Amendments. Senator Flores proposes the conceptual amendment which is attached to the work session document. In summary, the amendment revises throughout the section in Section 1 that an employer shall establish such a program to mitigate poor air quality from wildfire smoke. It clarifies in subsection 1A, an employer must establish and implement such program to mitigate the exposure of employees working outdoors who occasionally, frequently, or constantly perform critical tasks outdoors. It makes also conforming changes throughout the entire section. It revises subsection 2 that the employer shall monitor the air quality before and as conditions change during each shift. It replaces the current provisions in subsection 3 and instead requires the administrator of the Division of Industrial Relations to establish measures that an employer must take to reduce the exposure of an employee exposed to air quality where the air quality index is 150 or more but less than 200 or more than 200. Further, the administrator shall establish an AQI level caused by wildfire smoke at which an employer shall not allow an employee to continue to work outdoors. It adds to subsection 8 that provides exemptions to the provisions in section 1 for any employer who is a mine operator or employs commercial truck drivers. Thank you, Chairperson.
Thank you so much, Mr. Ashton. Do we have any questions on SB 260? Senator Rogich?
Thank you, Chair. I'm going to vote yes on this and reserve my right to change my vote on the floor. I think it still needs work, and I encourage the parties to continue discussions. Thank you.
Thank you very much. Senator Steinbeck?
Yes, I'm going to vote no on this and reserve my right also to change when we get to the floor. This is something we absolutely have to address, and I still think it's best through the regulatory process, and we're moving that way. Thank you.
Okay, and also I'd like to say thank you so much to Senator Flores, who's had many, many, many stakeholder meetings and discussions on Senate Bill 260 to get us to a different place and is continuing to work with all stakeholders. So thank you to everyone who's been involved in those discussions. With that, I will accept a motion to amend do pass Senate Bill 260.
Motion to amend and do pass Senate Bill 260.
Thank you so much. We have a motion to amend do pass Senate Bill 260. Do we have from Senator Daley? Do we have a second? A second from Senator Scheibel. Any further discussion? Okay. All in favor, please say aye. Aye. Any opposed, say nay. Okay. Please note that we have nays from Senators Ellison and Steinbeck, and the motion does carry, and the floor statement will be given to Senator Flores. And with that, we are going to move to Senate Bill 294.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 294 revises provisions relating to physician assistants and was heard on April 2nd. I will go straight to the amendments. Members, the amendment proposed on behalf of the Nevada Academy of Physician Assistants proposes to remove all sections from the bill. In other words, it is a cut and replace. Instead, the amendment directs the Board of Medical Examiners and the State Board of Osteopathic Medicine to revise regulations prohibiting physicians from simultaneously supervising not more than 6 physician assistants instead of currently 3 physician assistants. Thank you, Chairperson.
Thank you so much. And I'm actually also going to hand it over to our legal counsel because I know we've had a lot of questions on this bill, and I'd like him to share his thoughts after having looked at this amendment.
Thank you, Chair. Jeff Coulomé from LCB Legal Division. For the record, just to mention at a 10,000-foot view for everybody, the structure of what's going on here when we talk about the difference between the law and regulations, the NRS, the Nevada Revised Statutes. That's what the legislature does. The NAC, the Nevada Administrative Code, that's what the executive branch agencies do. The state constitution vests the legislative power, obviously with the legislative branch. And that's what the bills do, is amend the NRS. The executive branch agencies don't have inherent authority to adopt regulations. What happens is the legislature, through the NRS, delegates power to the agencies to adopt regulations. So the way something like this usually comes out in the drafting is there are sections in the NRS that make those grants of authority. One, for example, is NRS 630-275. The board shall adopt regulations regarding the licensure of a physician assistant, including but not limited to, and then it'll say a bunch of stuff, educational requirements, et cetera. The way this usually comes out in the drafting is the bill will add to that authority something that says the regulations must contain a provision that authorizes a physician to simultaneously supervise 6 physician assistants, or something to that effect. That's a specific and narrow delegation of authority that gives a clue to the agency to amend the regulation accordingly with that grant of authority. But this bill, as Mr. Ashton said, doesn't affect any other provisions of existing law, and the legislature does not and will not, and this bill does not directly amend any other provisions in the Nevada Administrative Code either. And I hope that is helpful, Chair.
Thank you so much, Mr. Coulombe. With that, do we have any questions on Senate Bill 294? Senator Ellison? Turn on your microphone for us, just so we can all hear you and get it on the record, then. Thank you.
I'm sorry, madam. I still got a lot of questions that I need to ask on this. I'm going to go ahead and I could go either way, yes or no, and I just need to get some answers out of this because we hear that there's other amendments that might show up. So I'm going to go ahead and vote no and then reserve my rights because I think I can get them answered prior to the meeting, and I will let you know ahead of time. Okay. Thank you.
Thank you so much. And Senator Steinbeck?
I'm going to vote yes and reserve my right to change later. Thank you.
Thank you both so much. Seeing no further questions, I'm going to accept a motion to amend, do pass Senate Bill 294. Thank you so much. We have a motion from Senator Scheibel, a second from Senator Lang. Do we have any further questions on Senate Bill 294? Okay. Not seeing any. All in favor, please say aye. Aye. Any opposed, say nay. Okay. Please note that that this motion does carry. We do have a nay vote from Senators Daly, Ellison, and Rogich, and the floor statement will be assigned to Senator Flores. And with that, we are going to move to Senate Bill 311, Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 311 was heard on April 7th. It requires certain alarm companies that entered into a contract with a customer as soon as practicable after receiving notice from a customer that the alarm system is defective or inoperative to repair or replace the defective alarm system or cancel the remainder of the contract and refund any unearned money. Amendments. Senator Ellison proposes to amend the bill by removing in Section 1, Subsection 1, that an alarm company shall act as soon as practicable and instead require the alarm company to act within 5 business days after receiving notice from the customer. Thank you, Chairperson.
Thank you so much, Mr. Ashton. And with that, do we have any questions on Senate Bill 311? Okay. Not seeing any questions, I will accept a motion to amend, do pass Senate Bill 311.
So moved.
Thank you so much. We have a motion to amend, do pass from Senator Flores. Do we have a second? A second from Senator Scheibel. Do we have any further discussion? Okay. Not seeing any. All in favor, please say aye. Aye. Any opposed, say nay. Okay. Wonderful. This motion carries, and we will assign the floor statement to Senator Ellison. And with that, we will move to Senate Bill 317, Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. SB 317 was heard yesterday, and for the sake of time, I will go straight to the amendments. The amendment deletes sections 1 through 13. It revises in section 14 or removes the requirement for insurers to include 12 specialists from certain fields, adds a requirement that listed physicians must accept and treat industrial claimants, adds a requirement for annual panel updates in December, provides that physicians who cancel contracts may be removed, and provides that insurers can remove physicians every 3 years, among other changes. In Section 17, it retains deleted provisions that the employee must prove by clear and convincing evidence stress-related injuries. It adds certain licensed mental health providers that may treat injured employees for stress-related injuries. It adds certain new provisions as well. It allows authorized treating physicians to allow for the routine follow-up care of an industrial claimant by a licensed physician assistant under certain conditions. It requires the Division of Industrial Relations to select a national recognized evidence-based drug formulary for the workers' compensation system and publish information about the formulary on the internet, and sets forth the provisions in items 16A through F on the bill page regarding this formulary. It makes certain exceptions to subsections 4 and 5 in NRS 616B 353 relating to certain bonding requirements for third-party administrators for an association of self-insured employers, and it makes certain other amendments. Thank you, Chairperson.
Thank you so much. I'd also like to thank all the stakeholders who worked intensely on this bill, including our behind glass do not break vice chair, who has a comment to make right now.
Thank you, Madam Chair. Just wanted to include in the amendment, I know the Division of Insurance came up and talked about the effective date for, I think it was Section 39 regarding the premium caps, to make that effective January 1st, 2026, should be included in the draft amendment, or the amendment as drafted.
So for the committee, please note this new effective date, in addition to, just for that one section, in regards to Senate Bill 317, and that will be included with this vote that we're going to take momentarily. But do we have any questions on Senate Bill 317? Okay. With that, I'll accept a motion to amend, do pass Senate Bill 317.
So moved, Madam Chair.
Thank you so much. We have a motion from Senator Flores. Do we have a second? A second from Senator Scheibel. Do we have any further discussion? Okay. Seeing no further discussion, all in favor, please say aye. Aye. Anyone opposed, say nay. Okay. With that, this motion carries unanimously, and thank you, Senator Daly, for that update, and we will assign you, not surprisingly, the floor statement. And we will move to Senate Bill 327, Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 327 was heard on March 21st. It requires bonds that an applicant for a contractor's license and a licensed contractor are required to obtain under certain circumstances to be provided by a company who is listed as a certificate holding company in the United States Department of the Treasury, Circular number 570. There were no amendments. Thank you, Chairperson.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 327? All right, not seeing any questions, I will accept a motion to do pass Senate Bill 327.
Motion to do pass Senate Bill 327.
Thank you so much, Vice Chair Daly. Do we have a second? A second from Senator Scheibel. Do we have any further discussion? Okay. Seeing none, all in favor, please say aye. Aye. Any opposed, say nay. Okay. This motion carries unanimously, and Senator Cruz Crawford will be assigned the floor statement. And with that, we will move to Senate Bill 338, Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 338 was heard on March 31st. It prohibits a ticket provider from offering, displaying, or advertising any ticket price without clearly, conspicuously, and prominently disclosing the total price of the ticket with certain exceptions, or to misrepresent any fee or charge. A ticket provider must disclose certain information through various means to consumer before purchase of a ticket and refund within 30 days the full ticket amount under certain circumstances. Amendments. Senator Pacina proposes the conceptual amendment attached to the work session document, which in summary deletes Section 9 that authorizes a person injured to bring certain civil actions, and adds in Section 5 exceptions to ticket refunds in case of a cancellation due to certain emergencies or disasters. Thank you, Chair Pacina.
Okay. Thank you so much. Ticket bills are always a lot of fun and never bring any bad blood. With that, do we have any questions on Senate Bill 338? Okay. Not seeing any questions, I'll accept a... Oh, did you have a question?
No questions.
Okay. I will accept a motion to amend, do pass Senate Bill 338.
So moved, Madam Chair.
Thank you so much, Senator Flores. Do we have a second? Second. I think Senator Steinbeck might have beat you to it, but it's close. Do we have any further discussion on SB 338? Okay. Thank you all so much. With that, I will accept, all in favor, please say aye. Aye. Anyone opposed, say nay. Okay, thank you so much. Senate Bill 338 the motion does pass unanimously, and I will assign myself the floor statement. And with that, we will move to Senate Bill 354. Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 354 was heard on March 20th. It prohibits certain public and private health plans from requiring step therapy before providing coverage for a drug that prevents the acquisition of HIV or treats HIV or hepatitis C. Amendments. Senator Stone proposes the attached conceptual amendment to the work session document. In summary, the amendment removes Nevada Medicaid and the Public Employees Benefits Program from the bill's provisions to retain their current authority to impose step therapy before providing coverage for a drug that prevents the acquisition of HIV or treats HIV or hepatitis C, and also changes the effective date. Thank you, Chair.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 354? Okay, not seeing any questions. I will accept a motion to amend to pass Senate Bill 354. We have a motion from Senator Scheibel. Do we have a second? Second. A second from Vice Chair Daley. Any further discussion? Not seeing any. All in favor, please say aye. Aye. Any opposed, say nay. Okay, this motion carries unanimously, and Senator Stone will be assigned the floor statement. And with that, we move to Senate Bill 375.
For the record, Patrick Ashton, Research Division, LCB. SB 375 was heard on April 4th. It revises various provisions related to the governance, membership, oversight, reserves, and investments governing state-chartered credit unions. Amendments. Brian Reeder, on behalf of the Nevada Credit Union League, proposes the attached conceptual amendment to the work session document. In summary, the amendment clarifies in Section 1 that a credit union must also be approved for the low-income designation, revises Section 5 to clarify that vacancies on the credit and audit committees are not subject to the same procedures as vacancies in the board of directors, and removes Section 13, subsection 2. Thank you, Chairperson.
Thank you so much, Mr. Ashton. I'd also like to comment on Senate Bill 375 and thank the credit unions with Mr. Reeder, to thank the banks along with Mr. Kane for working together to come to a solution on this one where maybe no one's entirely happy, but everyone is moving forward. So thank you all very much for working together to get us to a good place on 375. Do we have any questions? Okay, with that, I'll accept. Oh, sorry. Go ahead, Senator Lang.
I just want to let you know that my husband serves on the board of a credit union, and but I feel like I need to disclose that for transparency reasons. But I will go ahead and vote on this motion.
Thank you so much, Senator Lang. And with that, I will accept a motion to amend do pass Senate Bill 375.
Motion to amend and do pass Senate Bill 375.
Second.
Thank you so much. We have a motion to amend do pass from our Vice Chair, Senator Daley, a second from Senator Flores. And with that, do we have any further discussion on 375? Okay. All in favor, please say aye. Aye. Any opposed, say nay. Okay. This motion carries unanimously, and I will assign myself the floor statement, and we will move on to Senate Bill 379. Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 379 was heard on March 31st. It prohibits a person from engaging in the business of a distributed generation system financier, a manufactured home financier, or a covered lessor without being licensed by the Commissioner of Financial Institutions as an installment lender. Amendments. Senator Doniate proposed the attached conceptual amendment to the work session document during the bill hearing. In summary, the amendment clarifies in Section 13 that a verbal communication must be conducted prior to the installation of the system, and provides in Section 15 a financier may cause a distributed generation system to be disconnected or otherwise prevent its use if the borrower, lessee, or host customer, as applicable, failed to make 3 consecutive monthly loan payments. Thank you, Chairperson.
Thank you so much, Mr. Ashton. All right, do we have any questions on Senate Bill 379? And this is another bill the stakeholders really worked together, and Senator Duniate should be commended because it was a great opportunity for all the stakeholders to get together on that. Seeing no questions, I will accept a motion to amend due pass Senate Bill 379.
So
Motion.
moved.
Second.
Okay. I think, Senator Ellison, that Senator Scheibel might have beat you to the motion, and Senator Daly got the second, but we thank you all so much. And with that, do we have any further discussion on 379? Okay, not seeing any. All in favor, please say aye. Aye. Any opposed, say nay. Okay, wonderful. The motion carries unanimously, and Senator Duniate will take that floor statement, and that will move us to Senate Bill 386. Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 386 was heard on March 31st. It authorizes the Board of Massage Therapy under certain circumstances and after review of the credentials of an applicant to grant a license to an applicant who does not otherwise satisfy the requirements to practice massage therapy, reflexology, or structural integration. Additionally, the board may issue a temporary license to an active license holder from another state who satisfies the requirements for a temporary license, and the bill also establishes new provisions concerning certificate holders operating certain establishments. Finally, the bill authorizes the executive director of the board, in addition to the board members, to issue subpoenas and eliminates a requirement that the board alternates its meeting locations between northern and southern Nevada. Amendments. Colleen Blatt, on behalf of the Board of Massage Therapy, proposed the attached conceptual amendment during the bill hearing. In summary, the amendment revises in Section 1 certain minimum hours of instruction. Thank you, Chairperson.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 386? Okay, not seeing any questions, I will accept a motion to amend due pass Senate Bill 386.
Motion to amend due pass Senate Bill 386.
Thank you so much, Vice Chair Daly, for the motion. Do we have a second? A second from Senator Lang. Any further discussion? Okay, all in favor, please say aye. Aye. Any opposed, say nay. All right, that motion carries unanimously, and Senator Scheibel will be assigned the floor statement. And with that, we will move to Senate Bill 429, which we heard yesterday.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 429 revises provisions relating to social work and was heard yesterday. And I will go straight to the amendments. Senator Titus proposes the attached conceptual amendment to the work session document. In summary, the amendment removes the current provisions of the bill and instead provides the appropriation in Section 17 to the two schools of social work at UNR and UNLV. Both schools must use these funds to provide scholarships to social work students who complete their field practicum at a practicum site that is a certain type of medical facility or is in certain rural or underserved areas in the state. Thank you, Chair.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 429? I know it's very fresh in all of our minds from yesterday. All right, I will accept a motion to amend due pass Senate Bill 429.
So moved.
Thank you so much, Senator Flores. With the motion, do we have a second? A second from Senator Scheibel. And do we have any further discussion? Not seeing any. All in favor, please say aye. Aye. Any opposed, say nay. Okay. This motion carries unanimously, and Senator Titus will be assigned the floor statement. And with that, that will move us to Senate Bill 437. Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 437 was heard on March 7th. It authorizes an internet consumer lender to apply for a license to engage in the business of lending for an office or place of business located outside of Nevada without having a physical location inside the state. Amendments. On behalf of Upstart, this attached conceptual amendment was proposed during the bill hearing. In summary, the amendment clarifies in Section 1 that the requirements for a contract only apply if not preempted by federal law, and revises in Section 2 the definition of internet consumer lender as a person who makes, solicits, brokers, arranges, or facilitates consumer loans exclusively through the internet. Thank you, Chairperson.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 437? Okay, not seeing any questions, I will accept a motion to amend due pass Senate Bill 437. So moved. Thank you so much. We have a motion from Senator Scheibel. Do we have a second?
Second.
A second. I believe Senator Lang just beat you to the punch, Senator Flores. Do we have any further discussion? Senator Ellison.
Yes, I'm going to vote this bill out, but I want to reserve my rights if I could.
Okay. Sounds good to me. With that, all in favor, please say aye. Aye. Any opposed, say nay. Okay, the motion carries unanimously. Senator Ellison, that is noted, and I will assign the floor statement to Senator Steinbeck. And with that, Mr. Ashton, we will move to Senate Bill 439. We're getting close to the end.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 439 was heard on April 7th. It authorizes an estate distillery to receive neutral or distilled spirits in bulk from a supplier for storage and bottling. Additionally, the bill allows an estate distillery to sell other alcoholic beverages at retail under certain circumstances. Amendments. Minden Mill Distilling proposed the attached conceptual amendment to the work session document during the bill hearing. In summary, the amendment revises Section 1 and clarifies in subsection 2 of Section 1 that an estate distillery may receive neutral or distilled spirits in bulk from a non-affiliated supplier and deletes Section 2 entirely. Thank you, Chairperson.
Thank you so much, Mr. Ashton. Do we have any questions on Senate Bill 439? Senator Rogich?
Thank you, Chair. I'm going to vote this out of committee, but reserve my right to change the vote on the floor. I'm hoping that the parties can still continue to have discussions with regard to the small businesses. Thank you.
Thank you so much. Senator Steinbeck.
Ditto.
Ditto.
All right. Love this. All right. Now we need to start doing this during testimony as well. All right. So Senate Bill 4039, I will accept a motion to amend do pass.
Motion.
Thank you. We have a motion from Senator Lang. Do we have a second?
Second.
A second from Senator Daly. Any further discussion? Not seeing any. All in favor, please say aye. Aye. Any opposed, say nay. Okay. This Senate Bill 439, that motion does carry unanimously to amend do pass. And with the noted comments from Senators Ellison, Rogich, and Steinbeck, and I will assign this to Senator Scheibel. And this brings us to Senate Bill 440, Mr. Ashton.
For the record, Patrick Ashton, Research Division, LCB. Senate Bill 440 was heard on April 9th, and I will go straight to the amendments. On behalf of Nevada, Edith Duarte, on behalf of Nevada Solar Association, proposed this attached conceptual amendment. In summary, the amendment deletes sections 1 through 12 concerning solar lenders. It removes the current provisions of section 13 and instead establishes procedures requiring associations to respond to installation requests within 35 days. It removes certain provisions from sections 15 through 20 as outlined in the conceptual amendment and deletes sections 22 and 24. It removes the current provisions of section 25 and instead requires a utility to complete final inspections of net metering systems within a reasonable time frame, and replaces section 28 subsection 9c with requiring the Commission to adopt certain regulations. Thank you, Chairperson.
Thank you so much, Mr. Ashton, for this marathon today. With that, do we have any questions? And I should say as well, thank you as well to the stakeholders on this for having a lot of meetings and working on consensus. And with that, do we have any questions on Senate Bill 440? Okay. Senator
Madam Chair, I
Flores?
just wanted to let you know that I will be voting it out, but I will be reserving my right.
Thank you so much, Senator Flores. And with that, do we have any other questions? Okay. Seeing no further questions, I will accept a motion to amend do pass Senate Bill 440. Thank you so much. A motion from Senator Lang. Do we have a second? Second. A second from Senator Scheibel. Do we have any further discussion? Okay. Not seeing any further discussion. All in favor, please say aye. Aye. Any opposed, say nay. Okay. Please let it be noted that this motion carries unanimously with the comments from Senator Flores, and I will assign this floor statement. Who would like this floor statement? I was going to give it to Senator Flores, but then when he reserved his right, I changed my mind. Do I have a volunteer? I'll do it. Oh, go ahead. No. Senator Lang, it's all yours. Thank you so much. And that will move us to our final portion of the agenda today, which is public comment. I'd also very much like to thank the committee for this marathon today. It was not a sprint, and I really appreciate your engagement and reviewing some of these bills where it's been a long time since we've reviewed them, as well as all of the amendments. So with that said, anyone who'd like to make public comments, please come on up in our physical locations. Not seeing anyone doing that, we will move to the phones. Broadcast, do we have anyone on the phone lines who'd like to make public comment relating to commerce and labor?
If you would like to provide public comment, please press star 9 now to take your place in the queue.
Good morning. Thank you, Chair Pazina and members of the committee. My name is Steve Messenger. That's Messinger. I'm the Policy Director for the Nevada Primary Care Association. I want to call this committee's attention to the critical funding that Nevada's community health centers stand to lose. These dollars come from a federal prescription drug discount program called 340B. Through an unfortunate accident, this legislature did not introduce BDR 52-511 that would have protected this funding. We are optimistic that this body will work to correct this mistake and find a place for this language. This committee has worked so hard to increase access to healthcare for all Nevadans, and particularly for underserved communities where our health centers may be the only source of access. It would be a tragedy to allow these resources to go away or to have to replace these dollars with state funds. Thank you for your consideration.
And thank you so much for your comment and engagement. Broadcast, is there anyone else on the line?
Chair, you have no more callers wishing to provide public comment at this time.
Thank you so much. And on behalf of the Vice Chair, myself, the entire committee, we'd also like to thank the staff who worked around the clock to put together this binder, who has been working until hours of the night / early morning that no one should have to as we approach our deadlines. So please know how grateful we are as a committee and how thankful we are for all of you. And we look forward to seeing you tomorrow at 8 a.m. And with that, we are adjourned.